Okay, this is LAWS 12066 land law, and today we're looking at topic 6 on co-ownership. And I indicated to you, I think in an email, that I've got to finish the class today at 3, so we'll run for about just an hour. So I'll just make a few observations to start with before we then look at the tutorial problems. Co-ownership is an interesting area. It's interesting in the sense that it's, very typical, particularly within residential transactions, for there to be more than one potential owner, particularly where people are in a relationship and they're seeking to purchase property together. And then these ideas of how we own the property or how we co-own the property, either as tenants in common or joint tenants, or maybe I should say joint tenants first before I say tenants in common, is interesting. And, in sale of contract documents, or the standard form sale of contract in many jurisdictions, the contract will have on it, on the front page, very typically, where you're filling in the details, particulars of the parties, it'll have printed on it the capacity in which more than one owner, if there is more than one owner, are actually purchasing the property. And the truth of the matter is that there's very often the case that very little consideration is given to this, except when it's actually explained to the prospective purchasers for the first time. And then even then, very, very little actually appreciation is actually had in that context of the implications and consequences. But as you will have seen from the material, from the texts, that, a lot of issues and problems can occur subsequently where there is a relationship breakdown, and then dealing with the property law implications of that, which are not necessarily thought about at the outset of entering into the transaction, the purchase. Of course, co-ownership is not something that is exclusively the germane to residential purchases or transactions. We can talk about a whole range of transactions here. We can also, and even though most of the material, most of the discussion here is in the context of land, we can talk about the co-ownership of various forms of property, but our focus is really in relation to land here. Those two types of co-ownership are tenancy, joint tenancy, and tenancy in common, and you will have seen from the materials the different ways in which the joint tenancy operates as opposed to how the tenancy in common operates. Basically in terms of the unities, where with a joint tenancy we need 4 unities, and there is also this idea of the right of survivorship, or the jus ascendendi, which doesn't exist for tenancy or tenants in common. The topic is basically looking at the nature of those different types of co-ownership. What are the rights and obligations between the co-owners? How can a tenancy co-ownership situation be brought to an end? And importantly, the idea of the severance of a co-ownership, particularly of a joint tenancy, and how that can through the severance become a tenancy in common, and what are the implications and consequences there? And of course, the problem question, the rather knotty problem question that I've posed for you, if you had a look at it, is precisely about that. So the focus of the tutorial questions is really, the first question is a policy question, policy style question, and as ever, I'm trying to get you to think about and reflect upon some of the changes that have taken place in this area and the policy that underpins those changes and how we should best respond to that, on the one hand, and then secondly, a problem-solving question involving one of the more challenging areas, which is about actually the severance of a joint tenancy and the extent to which that is recognisable, and principally, mostly, we're concerned with equities response, but we're also concerned with any relevant legislation that is important in the context of a severance. And quite specifically in Queensland, of course, we do have legislative provisions with our more modern, forward-looking legislation in Queensland than is the case in some other jurisdictions. All right, so without any further ado, given the more limited time that I've allocated today, let's move on to the problem questions, and let's have a look at problem number 10. Who would like to have a go at throwing in their hat in the ring in problem 10? I can see Roger nodding. That's fine, Roger. You'd like to have a go?
I posted an answer, so I nominate Roger.
I actually haven't done it yet. I'm having too much trouble with it. I can't even understand it. It's one of the versions one here.
Grant, is that a self-nomination, or is that a joint nomination, and has it been sufficiently advised in advance?
No.
Well, in the absence of a spousal relationship...
spousal. They're very, very fraught. I noticed that was in parentheses in your answer, Grant, and that's a very fraught environment in the modern period.
Yeah, I mean, look, I'm happy to, I guess, probably speak to my written response a little bit.
How about, Grant, you can, that's right, you can do that and start the ball rolling, and then maybe Roger and Lisa can come in. Yep. Are you happy to do that?
Yeah, happy. Really, I just wanted to preface this by saying that when I was reading the material, which was very extensive, it seemed to run off into a lot of different cases on a lot of very subtle issues. I guess I'd sort of formed an opinion that really up until sort of that case, which I can't even think of the case now, Callow, up until the Callow
case. Yep.
I thought it was relatively clear in the sense that to claim an occupation fee or rent, that the plaintiff has to be unreasonably denied access. There has to be something either physically presenting them or a threat preventing them, or I can't remember the case, but the case with the cows, where, the cows case, where the land was basically being used to its capacity by one tenant, effectively denied, use and enjoyment by another party. So with that in mind, that's how I approach the question, because to me, there still has to be an unreasonable interference preventing access to that property or use of that property.
But what about, can I just toss this idea out? And yes, you're right, and you're right up until the point of Callow's case. But what do we do? And this is an open-ended policy question, right? What do we do in the circumstances of breakdown of a personal relationship? The idea that the person has to be ousted, the idea of ouster to enable to found a claim for occupation or rent prior to Callow, and also to some degree the previous decision, another decision before that, but mostly Callow. What is the policy driving this change that we don't? This almost the point comes through, particularly in Beasley's judgment, and of course Justice Beasley is a female. I say that just because I think that it is helpful to have different voices of judicial determination here, and I think it's quite fair and reasonable to make the point that where most of the decision making in matters of this nature, particularly in the context of breakdown of personal relationship, is being made historically by, middle-aged males of a certain background and of a certain context. I think other voices can shed a different light on how we should understand the consequences of circumstances and social conditions and so on and so forth. So, just what is the rationale behind the change that comes in Callow? Is it justified? That we no longer need Ulster. Lisa, yep.
Oh, look, I was just going to say, and I must admit, I haven't looked very deep.
You turn your sound up a little bit, Lisa, please.
Is that better?
That's better, thank you.
Is that better?
Yeah.
Okay. I haven't looked deeply into these questions, but I think that possibly what saw the policy shift in Callow was that social conditions have changed a lot. There's more women working, there's higher numbers of de facto couples, there's a greater number of relationships breaking down, and perhaps things had to change with the changing social climate.
Any thoughts, Roger, on the general points, or?
Well, really, not so much in particular at the moment. All I know is that it was a bit of a shift to do with our de facto relationships, and sort of, in the case of Callow, has undertaken to explain a social stigma attached to violent relationships as such. So I'm trying to sort of comprehend the entire case. Now I can't really seem to get much background on why it's so important and significant. And that's one thing I'm sort of having trouble with this case. I can't understand the significance of it.
Okay, all right. Grant, you got any? There seems to be a slight difference of emphasis there between you and Lisa. Do you want to explore that a little bit more?
From
Mute your
the
mic,
social
if you're not
viewpoint,
speaking, please. Yeah.
From the social viewpoint, I agree with Lisa 100%. And I think where I was also coming from, my response was, I'm not opposed to the change per se. I actually think that it's socially justified. Although I do have some reservations as to whether that was the place of the court, because to me it just seemed to take a very big step from being unreasonably denied due to circumstances where the history of cases shows that there has been domestic violence or something preventing that partner from having access to the property, which now just opens it up entirely to the co-tenant who has left, who may have left of their own accord without any of these type of circumstances. It ventures into an area as to, I don't know. I don't know if to me the presumption has just been taken too far, that the fact that there has been a breakdown in the relationship automatically entitles the person who is no longer cohabiting to have an entitlement to that rent. Because what if the person who had left was either morally or in some other way responsible for leaving, and they left of their own accord? Should that other person?
I accept that. But what about the practical consequence here? So that where there is a property that's co-owned by two individuals, and those individuals were in a personal relationship, there's a breakdown of the personal relationship. One of those individuals leaves because it's no longer appropriate or proper for them to continue to be in the same dwelling. The individual that leaves, and we don't need to necessarily look at the reasons for the breakdown, there could be many and various. The individual which leaves needs to accommodate themselves, and assumedly one doesn't, certainly in most instances in that situation, one doesn't actually walk out of a situation where one is a co-owner of a property and walk straight into being an owner of another property, sole owner, or a co-owner again, if that might be the situation of the person. but normally the person is moved into, in terms of accommodation, possibly in the short term, a rental scenario. So the person is actually paying rent, and if there's a mortgage associated with the property that's co-owned, that's shared between the co-owners, and there continues to be an obligation to meet mortgage repayments. And if, for example, which is in the current period, and the Callow case was decided in 2009, and I would suggest to you this is even more accentuated now, post-2009, where property prices are increasing in value, then the occupying co-owner continues to have the benefit of that, whereas the co-owner that is out of occupation can't have access to that occupation because it is, as Callow suggests, through that breakdown of relationships, no longer the case that they can continue to reside in the one dwelling together, but has to also bear the costs associated with the continuation of that, you know, the upkeep of that dwelling, but also has to bear the cost of separate accommodation in addition.
Yes, I was going to. Yeah, I was going to say something along those lines, would you believe, although not as eloquently as you, that if two people own a property together and are co-owners, regardless of the breakdown of the relationship, regardless of that, why shouldn't they be entitled to the benefit of half their property? Because, you know, they've still got to pay, I would have thought, 50% of the expenses on that property. They still have to pay rent or buy another property. And the co-owner that is staying in the property should either pay them rent and get someone in to help pay that, or they should buy them out.
But even if there is a purchase of that interest by the occupying co-owner, by the continuingly occupying co-owner, for the period where that doesn't occur, and very typically, of course, it's not an instantaneous thing. It takes some time for these matters to resolve themselves and the legalities to resolve themselves in terms of however that takes place, whether we're talking about, for example, breakdown of a marriage or breakdown of a de facto relationship. Then the owner that's out of occupation is actually arguably in a financially deleterious position for the period of being out of occupation and before the interest in the property is resolved, either through the sale of the property or the transfer of the interest to the occupying co-owner. And the other issue is that the occupying co-owner is not doubly burdened by accommodation costs during the period in which they continue to be in occupation and the non-occupying owner is out of occupation.
Yes, so they should pay rent.
Grant, any thoughts on that? I agree. I don't disagree with that at all. I guess I was just, after having read quite a few cases, I was just surprised that it just seemed to, and maybe I missed some cases in between, but even, because I think, because it was Beasley who made that decision in Callow.
Yes.
And it was Beasley who had also made the decision in Viviano.
Yes.
And to me, in the space of, I guess it's 10 years, the same judge who, to me, in the earlier case, had still, to me, followed that traditional sort of approach that there had to be some type of denial other than the status of the relationship itself. I was just surprised because I couldn't see in the middle there, other than, yes, I do understand social developments, and this is why I thought it may have been an area for the legislature to have a look at. But 10 years later, it just seemed like a very big jump to simply mandate that by status, we will simply impose that this applies by status. That was the bit that I had difficulty with.
Of course, the legislature, I think it's easy to say, oh, this is a matter, and often, you know, judges will say this is a matter for the legislature, but the legislature doesn't have its eyes on every aspect of the social life and context and how every part and aspect of law needs to be adjusted and amended. And often it's only through disputes that arise and come before the courts that brings this to light, that then it becomes, there's a focus on that or a bit of a spotlight on that, and then the legislature might decide to take action, as we've seen, for example, some of the provisions under the more modern and reform-focused Queensland legislation, particularly the LTA, we've seen pick up on things and incorporated into legislation, which really has come about as a consequence of comments and observations made through the case law historically. I'm going to throw in a very controversial and left field thought here, just to, as I like to do from time to time. So Justice Beazley, as I mentioned, is a female, and she seems to be driving this process of coming to what is arguably a flatter notion of what is the basis and the justification for the claim for occupation rent for a co-owner that's out of occupation. But the interesting thing of observation is that in a breakdown of a relationship, say, let's say conventional, I mean, we can talk about same-sex relationships, but say conventionally where it's a male and a female and there's dependence in that relationship, which is not atypical by any means, which of the co-owners in that scenario is normally the one that's out of occupation initially?
Oh, I think it's usually the male.
Yeah. And so the judgment in Callow actually, interestingly, strengthens the position of the out of occupation male in that type of a scenario that I've suggested to you.
Yes, it does.
Do you find that an interesting outcome?
Yes.
Yeah.
I certainly considered that as I was responding, and I did see the irony in a female judge making a decision that would, for the most part, based on the historical norms, assist males who are typically left a family home to the female and or children. Not in all cases, of course. But then, other than sort of that irony, that's as far as I thought about that. I thought that was interesting, but I still, to me, I guess I got hung up on what I mentioned earlier, that sudden change and the was it the role for the judiciary to make that decision and to apply that interpretation to social conditions.
I know we have this just grant. I know about the proper role of the judiciary, and I know that you tend to err on the side of, well, I suspect from your observations from time to time that you are concerned about judges overreaching from time to time. My own view is, for what it's worth, and it's only one view, by the way, is that I think it's entirely appropriate for judges to respond to changing social conditions and to bring about developments in the law that are necessary and needful. What's interesting is, Roger, yep.
I was just going to say, I'm just reading what she's actually said during that case, and one part that's stuck out at me in particular, she's said that to describe such a relationship breakdown as an actual ouster involves a fiction, and it is better to recognise such a breakdown as an independent ground for charging an occupation rent. Now, to me, that signifies that she's trying to equalise the equation when it comes to property settlements. That's the intention that I'm getting behind her meaning. I'm not sure whether that's right or not, but certainly I'm picking up that she's trying to, well, balance the playing field, so to speak.
Any thoughts on that from anyone else? Roger's point?
Again, I'm not opposed to the change. I think the change is justified. I support the change. But what was missing is it was just a very fine, narrow statement saying this is how it is. That if a judge was going to make a change, and I know we're getting off topic here, that if a judge wants to make such a wide-sweeping change, then to me, they should at least explain themselves in terms of this is why they're making that decision, other than simply a statement of fact saying, look, that's unreasonable to do that now, therefore I'm doing it. And that's sort of how I interpreted that.
I think, okay, I mean, that's fine. I think Roger's point about, you know, what Beazley is actually identifying is that there's an artificial fiction in this idea of having to prove ouster for the purposes of getting access to an occupation rent, because ouster is actually, you know, the forceful removal and the deprivation of your right, where the truth of the matter is that in this scenario of personal relationship, often that isn't the case. In fact, it's a voluntary decision to leave, but it's underpinned by the reality that it's impossible and totally inappropriate for both owners to continue to occupy the one dwelling, but that there could never be an ouster in that situation because of the voluntary nature of the decision. And that was always the sticking point with regard to the occupation rent or occupation fees, it's sometimes referred to. But the realities of life and the realities of the commercial situation of accommodation today, I think, makes the approach in Callow highly commendable. But it is absolutely a shift in gear, as Grant has indicated. There's no doubt about that. And of course, I've tossed this up because there's tentacles here in terms of it allows us to think about how property rights and rights with respect to land operate within current conditions. What is the role of the law here? And where do we strike the balance? And do we look to the legislature, or what is the role of the courts? You know, I think that a robust judiciary that is prepared to see changing circumstances and changing conditions and to move forward, but it has to do it in a principled way from how the law has evolved over time, is entirely appropriate. And then if that can be picked up by the Parliament and responded to in a more detailed and straightforward way through legislative provision, all in good. But the Parliament is not acting across the entire landscape of control and definition within our lives and within the life of our society. And so, judges have to be responsive to this. It behoves the judiciary to make the law and the judge-made law of continuing relevance to the conditions of the time. Now, I know that not all judges would agree with that position because, they take more conservative views about their role and their perspective. But the question, as posed, and the quotation from Callow, tosses all these things into the mix for you and allows you to reflect and explore those, and that's the purpose of the exercise. All right. So we need to move on because of the time. So that's problem question 10. All right, now let's move on to this. I won't say straightforward because it's not straightforward in the least. The problem question 11, dealing with the averages. So here we have, another. Now we're cast the problem of co-ownership and how we deal with the problems where co-ownership breaks down in a different way. But nonetheless, we still have a scenario here of a breakdown of a personal relationship, but we have a number of other factors that are at play in terms of what's going on. And this question, of course, immediately tosses up the idea of severance and how can the particular type of co-ownership, the joint tenancy, be severed, and whether what's being done here is acceptable, legitimate, and so on and so forth. So, who would like to have a have a toss at this problem question. Come on, Grant, you can toss us around a little bit. You know, you've had a bit of a go at it.
All right.
At least an aspect of
it. Well, yeah, I tackled one aspect because to me it lent itself to a lot of sort of sub-issues. And actually I might start with what I didn't address, which was, to me, what I wanted to investigate further, but lack of time, was in terms of the change of mind situation. There was a case, Sprott v. Harper, which spoke about whether it's concluded in terms of severing the joint tenancy, that there were some cases suggesting that the moment that there is acceptance or an indication of it, that is enough to sever it. But then in that subsequent case, it seemed to suggest that there was still room for a change of mind.
As you are talking about those broad ideas that's coming from some of the case law, just take us back a little bit, can you, to the scenario in the problem question. And I hope that all three of you have the question in front of you. Just what features within the information matrix would you be suggesting indicate the points you've been making?
The point that I didn't explore that I wanted to was about the change of mind, was where it was more an emotional statement on the facts that that Mr. Everidge just said that she can do whatever she wants. I don't care. That wasn't in itself, to me, conclusive of an agreement to say, okay, this is what we're agreeing to. I wanted to explore whether that constituted sort of an agreement to say, yes, I agree to sort of sever the title, and whether that was sufficient. And in the alternative, if it was, well, then was there a change of mind demonstrated by his later behaviour that basically sort of undid that? So that was the part of the problem that I was referring to there. And
you can imagine, right? You can imagine, if you haven't read through the scenario, you know, basically we've got the Everidges who were owned as joint tenants, farming situation, not residential dwelling, but farming situation. So you need to then think about the implications and consequences of a farming situation as opposed to a metropolitan residential type situation. So whenever you've got the scenario, think about the practical outworkings of that and how the law might look at that and respond to that, you know, because it's going to have different practical aspects and features. They were married, marriage broke down, Mrs. E seriously ill, then subsequently terminally ill. Basically, she tries to sever the joint tenancy by setting up her brother Joe as a trustee so that her share can go as a tenancy in common on her demise via her will, with her brother as executor and trustee of her estate for the benefit of her children, of which she had 5. And the issue, of course, was whether the severance was effective, in what legal framework is relevant to determine whether it's effective, and the various aspects of what was done there, okay? And so we've got basically the contest at the end of that, and, you know, Mrs. E dies, and so the contest at the end of the day is between Mr. E, who is asserting his interest in the property on his wife, Mrs. E's demise, as now the sole owner, you know, arguing that, as he would, that he took the whole on her demise through the operation of the right of survivorship. On the other side, you've got Joe as the executor of Mrs. E's estate and trustee, arguing that no, you know, there's been a severance and therefore the estate which I represent, takes a tenant's its share as a tenancy in common for the benefit of beneficiaries, namely the named children of Mr. and Mrs. E, but to benefit those children. Okay. So that's, you know, in nuts and bolts. All right. So we have to really decide whether or not there's been an effective severance of the joint tenancy. That's the first thing. Any thoughts on that?
Well, and look, I've only just briefly looked at this, but if without registration, there's no severance according to law. Now, why it wasn't registered, I don't know, but severance is only...
Sorry, Lisa, you don't need to register to effect a severance in equity.
No, that's what I'm saying. It is there is possibly a severance at equity, but not law. So section 59.
The question is whether there's an effective severance at equity or in accordance with equity.
Well, then you look at the case of Corrin v. Patton, don't you? And
Corrin Patton, absolutely.
See whether everything's been done that should have been done. I know they're not the right words, but
now that's good. Everything that has been done should have been done. Now let's go back to the fact scenario. If you've got it in front of you, what had Mrs. E done as the transferor, arguably the transferor of her interest?
Oh, well, she'd instructed her solicitors to take all necessary steps in relation to the electronic indefeasible title to transfer it, to register it.
Has she done anything before that?
I think what she's actually done is she's done first off, she's transferred her interest to her brother Joe at first instance, and then later, when it became clear that it was terminable, she's adjusted her will to include the children as tenants in common with her brother Joe as executive. Now, I don't know much, but from a trust point of view, I don't really think that could be quite legal, could it?
Well, let's just stop a minute. We have, how many documents do we have that have been created?
Well, there was the memorandum of transfer,
right?
Created.
Yes.
Initially.
So we've got a transfer document. Yes.
And
what else?
then there was the title documents to register the title.
Well, the title documents would already exist, of course. We have the memorandum of transfer, or the transfer, right? We call it transfer. We have a deed of trust, which has been created, right? So trust has been set up, express trust has been set up by Mrs. E, right, in favour of her children as beneficiaries, where Joe has been appointed as trustee. And then when she becomes aware that she's been, that she's seriously ill, she's then also written a will, and the will specifies how her estate is to be disposed of, or divided up upon her death. And of course, that relates to this aspect, this interest in this property. If in fact she can actually transact, she can deal with it by testamentary disposition. Okay. If there's no effective severance of the joint tenancy, it forms no part of her estate. It goes to the surviving joint tenant, which is Mr. E. And that's the thrust of his argument. Okay? So thinking about, if I just cast this a little bit in the context of the next assessment task that's facing you, that is the so-called moot assessment, some of which are choosing one option, and I'm hopefully some will choose the other option. But what are the arguments that are going to be presented on either side? Okay, how are you going to marshal the information, marshal the law, marshal the documents to support the argument? So how is Mr. E going to do that to support the continuation of the joint tenancy, that the severance is not effective and that he takes by survivorship the whole? Because if he does...
He's going to argue he's put...
Sorry, Roger?
He's probably going to argue he's put much more work into it, isn't he? It's one sort of like mental process at the moment I'm thinking of. You just argue that he put much more work into it.
That won't be adequate in law to satisfy the court as to why there hasn't been a severance, given what Mrs. E has undertaken. But that's what he has to do. He has to find some way to build an argument in that direction. Whereas Joe, on the other side, representing the estate, is trying to mount an argument in favour of the effective severance of the joint tenancy. So on the one hand, you've got no severance, joint tenancy maintained. I take the whole as surviving joint tenant. On the other side, you've got there's been an effective severance of the joint tenancy, and therefore the share that is now taken, 50% share, goes to the estate of Mrs. E. So the critical part here is whether or not there's been an effective severance. And Lisa pointed out, and Grant has in his response to the post, and I'll let you come in just in a minute, Grant, that whether, if all that's been done, all that needs to be done has been done. Now, there's also, you've referred to Corrin and Patton, very good, excellent. A couple of the posts also refer to Costin and Costin. Yes, acceptable. Yes, good. We also need to refer to specific provisions of legislation. What section am I thinking of?
Section 200 of the PLA? I
am. Now, you commented about Section 200, and look, careful analysis, and that's appreciated, and thanks for that. I'm just wondering what the underlying purpose of Section 200 is. Is it to better effectuate the severance, or is it to provide a technical process that, if not fully fulfilled, there will be no severance?
The latter.
It's almost foreshadowed, sir, almost foreshadowed. Any other thoughts on that? Maybe have you had... No,
well,
okay, yeah.
I think in terms of the purpose behind it, people, and I think particularly in a relationship breakdown, people make spontaneous decisions in the heat of the moment. Relationships can reconcile. They can be temporary separations. There's a whole range of things that can happen. There has to be a technical sort of guideline that you have to follow to make sure that that was the genuine intention, that the party genuinely wanted to sever the relationship or the title. And to do that, you have to have a process. And if you don't follow that process to the letter, then that allows too much room for ambiguity and for potentially the court to rule and make decisions that may not be what the party really intended to do. Or they may have only in the heat of the moment.
Yeah, of course, arguably, I would put it back that is the role of the court, to perform that task. Now, I've just via the chat, right, I've just given you, the three of you, I know Grant's had the benefit of looking at it, but I've given you, through the chat, Section 200. Right? Have a look at sub 1A and then sub 1B, 201A and then 1B. We probably need to read the opening words of sub 1 as well. Remember also, as you're reading that through, remember also that in Corrin and Patton, there was a voluntary transfer in voluntary in Patton, and that caused some concern, significant concern to some of the members of the court. Now, in Queensland, voluntary transfers, if this relates to a voluntary transfer situation, dealt with differently, as you know, so that voluntary transfers are covered under the LTA with regard to indefeasibility. But of course, in this scenario, we don't actually have registered interest, and so the benefits of the LTA have not yet been acquired with regard to any process of seeking to sever, even though the title, of course, is assumedly governed by LTA from facing. And the point here is that whether what Mrs. E has done is sufficient to satisfy the requirements of 200, which gives effect and efficacy in equity of a voluntary assignment. What has she done? We know that she's executed transfer. She's also drawn up an express trust. She's also subsequently drawn up a will. That doesn't really bear so much on the actual, the interest in the jointly owned property. That's something to be considered once we've decided that there's been an effective severance, and then we have tenancy in common, and then her share can be dealt with according to her will. Is there any sticking point in this, in the information? I mean, the instructions, as Lisa pointed out earlier, the instructions to her solicitors requested the mortgagee bank to take all necessary steps in relation to the electronic indefeasible title to enable the transfer to be registered, but it wasn't registered. The solicitors emailed the scanned-in copy, which of course is the practice now in Queensland with regard to the registering of interests, of all relevant documents to the husband's solicitors. But then nothing happened because he bellowed and shouted and carried on. But that's arguably an emotive response to the situation, and not, as Grant indicated before, not necessarily suggestive of an agreement. There is a severance here. How should we deal with this?
Well, it doesn't look, on reading this section, it doesn't look as if she did have anything more to do, because she'd done everything, which means that there would be a severance, because there was nothing more for her to do.
Grant?
This was an area where I wasn't clear on the facts, that whether she had done everything that she needed to do, because all of her instructions were to her solicitor. It's clear in terms of section, where are we? Subsection B, that they must have done everything. In other words, and this is where Costin comes into it, that as long as there is a revocable gift, because a gift can be revoked until it simply cannot be undone. That's where, from the facts, I didn't think that I thought she was still in a position to revoke, because she's issued instructions, but doesn't the transferee, doesn't Joe have to have executed the transfer or have been in a position to execute that transfer?
I think you've forgotten one little piece of information.
Which was?
What is Mrs. E's current circumstance?
Not good. Is she dead?
Not good. She is deceased. So, how does her demise factor into the revocability scenario?
Oh, she can't revoke it. But of course, Mr. E is going to probably argue that that was her intention to revoke it, and then it's going to come down to his word, isn't it, against whether the court thinks it was severed.
No, I don't believe that it will come down to his word. It will come down to an interpretation of the operation of Section 200, actually.
Can I say something?
Please do, Roger.
I'm just reading Milroy versus Lord, and it said that to effectively assign inequity, legal property capable of assignment at law, the assigner must have done all that is necessary to be done by him or her alone, even though something may remain to be done. Now, this leads to me to the conclusion that there's an element of intent, that the courts must decide what the intention actually was. And even though there was something that she failed to do, then it may not be a case it could be thrown out. Because in Miller versus Law, there was a failed attempt to assign that legal property at law. Yep. And that's why, that's why I'm interpreting it.
That's good, but the question then I would pose back is what more could have Mrs. E done from what she had done?
Well, I don't think she could have done anything more. But, you know, so according to that section that we're reading, she can't revoke it, and she's probably done everything she could have done.
What more, Grant, could she have done?
In the absence of facts telling me otherwise, wouldn't she have needed, for the transfer to be effective or the document to be registrable, it's one thing to request her solicitors to make preparation for it, but then she still has to be presented with the transfer document. She has to sign it in an authorised way and hand that over to the trustee. In this case, it would be the trustee, because she's not simply signing it to another individual. That, to me, was the missing step, and that's why, to me, it was revocable.
But it says she executed with her brother a deed of trust and a memorandum of transfer. Assumedly, she has signed, she's attended to the formalities with regard to the express trust, and she's attended to the execution of the transfer as far as she can do it.
How can she have executed the transfer if they're still in discussion with the mortgagee?
Well, she can certainly do it, whether or not it becomes valid, whether there's an impact there with regard to the mortgagee's authorisation or approval or whatever. That may well present as well, and the fact that we've got a mortgagee in play is another factor, undoubtedly, but there's also been communication with regard to that aspect. I'm just, you did point up this idea of revocability, and I'm just wondering what more Mrs. E could have done with regard to this revocable point. I mean, look, the truth, we're at 3. Sorry, go on. A quick comment. Sorry.
Yeah. Sorry, only in the sense that I've presumed that for a transfer to be valid, to execute a registrable transfer, which means that the transfer has to be valid, I'm not sure how that can be valid when it's saying that they're still requesting or giving instructions to the mortgagee. So to me, that doesn't have that concluded feel to me. That's the best I can describe it at this point.
Okay, that's fair enough. That's Lisa. A quick comment. Yeah.
Can I just ask, would her solicitors have emailed the documents to her husband's solicitors if they weren't signed?
Good point. Good point. Good point. Oh, so there's information there, sort of, arguably cutting a little bit both directions. The truth of the matter, of course, is that we're not, I'm not, and one cannot look for necessarily an absolute outcome here, okay? Because, and I deliberately give you a scenario like this because of its fraught nature and because the law, at the end of the day, it's about interpretation and about application as ever. And the provisions, the answer doesn't lie just in saying, oh, there's the provision, that's it, end of story. There's the case, that's it, end of story. It's never like that, okay? Because the facts are of a nature where they are different, always different, case by case, and it's a case of how we understand the body of case law, which is not always straightforward, and how we apply that in this situation. Also, in Queensland in particular, in light of the legislative provisions, some of which, we have a more modern version, which doesn't exist necessarily in the places, as I pointed out to you before, from where some of these cases have emerged from, and how we get the right balance at the end of the day, and then, in the end, coming to the view of what should happen. And it's not just a clinical exercise, people. I can't emphasise that enough. Not just a clinical exercise, okay? We need to be aware of the impact and the consequences, and the courts are aware of that as well in terms of the decisions that they're coming to. If we are convinced at the end, and with reference to the relevant law, that we can say that there has been an effective severance of the joint tenancy according really now to the provisions of the legislation in Queensland, Section 200, then there will be a tenancy in common between the two parties, between Mr. E and Mrs. E's estate. But before we get to a distribution according to her will of her share in the property, we then have a number of other matters that unfortunately we don't have time to go through, but there has to be an accounting with respect to the issue about occupation fee, for example, which we've touched on in the earlier policy question. And again, I think it's arguable that we need to think of that, of course, post-Callow, in terms of how that works in terms of the entitlement with regard to an occupation fee. There's also a sharing of the profits. Remember that this is a farm, and a farm is a business, and things are happening with regard to the farm. There's also the issue with regard to the contributions that were made, and the Mrs. E was performing bookkeeping duties and whatever, and how do we understand that as a contribution, and how does some of the case law help us to understand that? There's also the issue about improvements and repairs, which Mr. E undertook, but which weren't agreed to or weren't considered to be prudent necessarily by Mrs. E, and how that gets factored in. And these are the factors that basically, in terms of determining how the numbers get worked out, in terms of how much the estate actually gets, or whether the estate actually has to make a contribution. So there can be, money going a bit in both directions. So it's like with regard to the earlier scenario, it's all very well to talk about the fact of having a right to an occupation fee or occupation rent, but the out of occupation joint tenant, or tenant in a co-ownership scenario will still have obligations with respect to the property over which they have an interest. Example, mortgage obligations, mortgage repayment or loan repayment obligations under a mortgage. So there's a balancing act to be performed here with regard to the array of obligations and responsibilities concerning the money and where it's going and how it's being allocated and who's making decisions about that, to get the best and the most appropriate balance at the end of the day, okay? Both in terms of contributions, but in terms of obligations to make payments to the other party. And that question really, needed quite a bit of that, working through all of that. And as one or two of you pointed out, yes, it is a challenging problem scenario, but that's as it is in this area. But I want to finish with this idea, this point that, just a couple of things, that these type of situations in property law are not just mathematical problems, and they're not just clinical exercises. The law is a bit complicated and complex, but it's still, I want you to have a sense of the broader social purpose and social policy and how law needs to adjust to changing social conditions, not only in terms of personal relationships, but in business situation and in a whole lot of situations. And we also need to understand the impact of e-technology. A lot of the law that we're looking at in this course has come from past situations that was not in the midst of e-technology. We have to keep asking ourselves, how is this going to impact upon our understanding of these areas? Not only in terms of the change of social milieu, but also in the change of the technological context in which we function and operate today, individually, personally, relationally, and in a business context. You might also have seen in this topic that issue about the killing of a joint or of a co-owner. That's interesting, and I just suggest you have a look at that case in terms of the rights of co-owners in the context of where there's been a heinous crime by one co-owner against another. But in that context, you also need to think about, for example, the battered battered wife syndrome, if you like, where one co-owner is actually has endured period, sometimes a long period of violence by a fellow co-owner. And these type of situations take us into areas that are affected by different tracks of law. So obviously affected by criminal law, but there are also property law implications and consequences, as often there are. So there we are. That's the class on co-ownership. Can I just finish just by bringing to your attention? I did send you an email about this, but I've posted up 2 new web links under the welcome page or the weekly message page on the course website. One is from the Australian Law Council with regard to property law developments and property law group. The second is a very, very interesting, very, very recent decision from the New South Wales Court of Appeal on Torrens land, touching various aspects, including co-ownership, for which special leave to appeal to the High Court has been granted on the 20th of June and noted in the August High Court Bulletin, but that case has not yet been heard by the High Court of Australia. And I think this will be a very significant decision of the High Court going forward. Unlikely to have any outcome from the High Court before we've finished this term, I dare say. But you can certainly go back and have a look at the Court of Appeal decision. Very interesting. And guess who's sitting on the Court of Appeal bench?
Not Beasley.
You can have a look for yourself. So, but very divergent views in the Court of Appeal, and therefore justification for the High Court looking at this matter. But I suspect this will become a landmark decision once we get the High Court decision in due course. But that'll be some time off yet. Okay. All right, people, I need to leave now. I've got another commitment. Any final questions?
No, look, I had a quick question regarding the submission, but I'll email you. Thank you. I'll let you go. Bye.
Yes.
Bye, everyone.
Okay.
All good. Thanks, Michael.
Okay. Bye, Grant. Bye, Roger.